My name is Rolf Stevie Jr., and I'm a lawyer with the law offices of James A. Hinenhofer, APC. I'm a certified family law specialist, and I've been working with Mr. Hinenhofer since January of 1985. Today, I'll be sharing with you a little bit of information that you may need to know about concepts known as alternative dispute resolution processes, including specifically a concept known as mediation. Often I am asked to describe some of the alternatives available to try to resolve disputes in family law cases. Of course, one process is litigation, where a neutral judge will make the decision for the parties, in effect imposing his or her will on the parties, and this is the model you generally see in the family law courtroom. But in California, the policy of the law in family law cases is to promote settlement of litigation. This policy is set forth in Family Code Section 271. And toward advancing this policy, the family law courts permit, and in San Diego County they encourage, a wide range of dispute resolution processes. Some of these processes are referred to as ADR, or Alternative Dispute Resolution. And one of the most popular ADR options is mediation. Mediation is a dispute resolution process that the parties in a dispute agree to participate in, where they meet with a mutually selected, impartial, and neutral person that they've chosen, who assists them in trying to negotiate a resolution of their differences. Mediation leaves the decision power totally with the parties. And unlike a judge, the mediator does not have any power to impose a decision. The mediator does not decide what is fair or right. The mediator does not assess blame. The mediator's role is solely to try to facilitate a settlement or resolution of the dispute. And toward this goal, the mediator tries to help the parties understand the issues in their dispute. The mediator tries to facilitate constructive discussions to obtain facts and other information. The mediator tries to overcome whatever obstacles appear to be keeping the parties apart. And those obstacles come in many forms: fear, distrust, incomplete information, to just name a few. Now, toward the goal of overcoming obstacles, the mediator often does seek concessions from the parties. There is a give and take to this process. In some mediations, the parties have independent legal counsel that they consult with outside of the mediation, and in some mediations, the parties have their attorneys participate in the actual mediation session. Now, in order for mediation to work, there needs to be open and candid discussion. But this often gives rise to the question of how does one eliminate a concern that things said or concessions made in mediation will not be later used against the participant in litigation if the mediation is not successful. Now, the California legislature has addressed that concern with California Evidence Code Section 1119 that provides that all communications, negotiations, or settlement discussions by and between the participants in the course of a mediation shall remain confidential. So as a result of this legislation, in true mediation, there is complete confidentiality. Now, except for some very limited purposes. For example, signed agreements, if done right in mediation, are enforceable. So with the right mediator, mediation can be a very effective dispute resolution process, which is one reason it is widely used in family law cases. Other examples of dispute resolution options include private judging, and in the private judging process, the parties often independently hire an experienced retired judge. And this judge can be empowered to do most anything a superior judge can do, such as issuing enforceable rulings. Another dispute resolution option is arbitration. Arbitration can be binding or non-binding and advisory in nature. Until recently, a party had a very limited ability to appeal an arbitration decision. But now the appellate rights have been considerably expanded in arbitration, which is going to make it a more viable option. Other dispute resolution options include use of a special master or a referee to resolve specific issues such as discovery disputes or furniture divisions or tracing issues. There is also a process referred to as collaborative divorce. In concept, collaborative divorce is a process where the parties and their lawyers, in writing, agree to try to resolve conflicts by employing cooperative techniques rather than adversarial strategies and litigation. All of the people involved commit themselves to achieving a negotiated outcome and to refrain from litigation while involved in the collaborative process. So as you can see, there are many dispute resolution options available in family law cases today.